Here with two of the most experienced mooters and researchers of UILS Punjab University, and now they'll be giving their introductions.
Hi, this is Matisha Bansal. I'm currently in my 5th year. I've done around 4 to 5 moots. Yeah, and that's it.
Hi, this is Akhil Kamra. I am in the 4th year of the BCom LLB in the Punjab University. I have done 7 moots and I have been mooting since the inception of the law school. So,
would you guys please just explain the basic concept of mooting, the way you would explain it to a layman, as well as why is it necessary for a law student to at least do the mooting thing once?
So, according to me, what you can basically say a moot is, it's kind of a debate that is in a legal aspect. So, and also it makes you very crisp and brisk, about it, and it gives you a very nice exposure going there on the podium and presenting your thoughts to a judge. Yeah.
well, I would say that application of law to the facts, you will get practical application of the law, and you'll apply that very law to the facts, and gives you a real life platform to argue before a judge and to prepare a written submission for the judge. So, well, it is not only beneficial for law students or those aspiring to be litigants, but also to be the future judges and future civil servants, because they need to know what sort of applications of law will be there. That's it.
How much is the concept of moot relatable? Like I think you guys must have done internships in the course. So how much is the concept of moot actually relatable to the practical implementation in the courts and everything?
So I think according to the district court, if we go by that, the trial system is way more applicable. The mooting is more of a form of an appeal which you go through. So I think what you get more by mooting is the practical aspect of the things that you've done in your college, you've studied through your academic session, and how you should go about it and what that. When you go to the actual court, you find, okay, this is the similarity, how they are applying the law here. That is what the application comes to. That too in higher courts and but in the lower session, I think trial is more applicable there.
Well, I would completely agree by my fellow that actually the mooting gives you a platform, a real life like platform, where you can find in a trial, you'll find a court of trial, a sessions court, and in mooting you'll find the appeals court or the Supreme Court or High Court. So you'll apply the law and you'll research in a way that you are supposed to present before the Supreme Court or High Court. So that practical application is very important and very good in the mooting.
So basically mooting is actually good for you if you can actually see a practical aspect. And besides that, usually people have a lot of tips on how to go about the speaking aspect. Memorial and the research work is the one which is not given a lot of attention. So what would you like to tell me about that?
So I think for mooting, from my perspective, speaking is definitely a very important aspect, but people tend to ignore the memorial making, and it is by far a very, very important concept that's come to us. So we recently did a Moot prize, Media Moot. So in that, memorial making was given a lot of importance. The selection was based on memorials. 14 teams had to be selected on memorial basis, and also every round had 50% of scores reserved for memorials. So I would suggest everybody to actually take a lot of care how they go about memorial making. Certain steps should be followed. They should get a clarity of thought as to what they want to incorporate in their memorial and how they want to go about it. There should not be confused thoughts throughout the memorial. You need to read the proposition that has been given to you. You should clarify your facts, absolutely clarify them, and then you need to go about it. Your research work should be precise and actually hitting on the point that needs to be done. You don't need to go about making lengthy memorials of 80-90 pages, but it should be that you've made it in, even if you sum it up in 30 pages, it should be that 30 pages that actually matter and have all the content that you want to portray.
Well, given the fact that most of your arguments are based upon memorial, so memorial is a very important part of a moot. Firstly, as my fellow said, that most of the moots, most of the competitions have memorial selection as its basis. So you have to work on memorial. Memorial should not be haywire or very vague, but there are a couple of approaches to make a memorial. A person can make a memorial which is very vague, which will not show your through which you will not show your arguments to the opposite party. That would be very good in cases where where the memorial marks are not counted in the oral rounds, because obviously your memorial marks will be low. But in case where the memorial marks are counted and where there is the basis, the memorials are the basis for entering into competition, you have to make a very good and very organized memorial with particular structure. You have to follow a particular structure in order to appeal, which will appeal the judges. So I would say that memorial is a very important part of the moot.
So, except for the memorial and your research work, so basically your research work has to be very strong and precise for the memorial.
It has to be actually very clear. You should have a clarity of thought when you start researching on a particular topic. It shouldn't be that you're confused with your thoughts and then you take one approach and then in the other contention you're taking a different approach. It should all be organized and connecting somehow, so that it doesn't confuse even the judge who's sitting in front of you what this person has presented to us.
And what about the compendium? Is it a must in every moot?
From our recent experience,
compendium puts a very good impression on the judge, but most of the times judge won't see or open the memorial. Even if you direct the judge to open the compendium and refer to it, the judge won't even bother to open the compendium. So due to our recent experiences, we have seen that judges are more interested in the thoughts you have put in the memorial. Obviously, compendium, if the judge is there to grill you, and if the judges are with a mindset that they'll grill you with
only
respect to a
particular judgment or only on a particular point, like this is the judgment they want to target and they want to ask you everything about the judgment, only then are they going to refer to your compendium. Otherwise, compendium is only a very decorative part that you keep on the table so that they are impressed, okay, you've put in some effort even in your compendiums. Yeah, beyond that, nothing much.
And besides the memorial thing, the compendium, like what problems did you actually face? Like what were the objections taken up by the judges, or what all actually improvements you have made in this while?
So starting from the first moot that I went through to the last one, there have been a lot of things that we've been asked to improve with time. I think the first one being that you have to be very, very slow, not very slow but of a reasonable speed, and be very clear as to what you are trying to tell them through your oral arguments and your memorial both. They've always objected on this thing that we should put across our thoughts in a very nice way, not even in a complicated English or something like that, only in very simple words, but they should get the thought. So that is one point that I've always picked up, that you should be slow and you should actually put across your point very clearly.
Well, I would say that memorials have to be very organized, as I earlier said. Since the first moot till the last that I have recently done, I have seen that memorials should be categorized, should be bifurcated into, the argument should be bifurcated into several elements. By the approach that you are going to express, you are going to converse with a particular judge. You are not just for the sake of memorial, you are not submitting the memorial, you are having a conversation with a judge who is reading the memorial through your memorial. So you have to be very organized and you have to discuss every point element wise.
Are there some other experiences like in the moots you have done which you would like to share, and some tips which you would like to give?
Well, you have to, while speaking, you have to see what sort of time period you are provided. I have been to the moots like Hindi Dunant, which provide only 6 minutes per speaker, so you have to be very fast, and not very fast, but of a reasonable speed given the time. And I have been to Price Moot, the Oxford Moot, which provides you 22 minutes on an average to be each speaker. So you have to be of a reasonable speed so that you can have a conversation with the judge. So the fact that the speed of your arguments depend upon the time, it is very important to take into consideration. Secondly, I would say that yes, don't dodge the questions. When you are asked about a question, every speaker have a tendency to just dodge the questions and move on with the argument. It is very wrong. The judges are questioning you to get an answer. You have to satisfy them with a particular answer and with a precise answer. You don't need to beat around the bush to say an answer. You have to be very precise. So yes, as far as speaking is concerned, I would say that you should keep into mind the speed given the fact you have this much amount of time, and answer very properly. And as far as memorial is concerned, I would say that yes, you have to beautify your memorial. It is your brainchild. You have to beautify it as well by your arguments, by your cases, and your memorial need not have hundreds of cases. Even 10-20 cases would suffice if they are hitting on the right spot. So that's it.
So I'm sorry, just the last question. Like a lot of times the judges don't really allow, like they don't go for high court judges, right? Judgments. So is it actually like necessary that Supreme Court judgment should be taken into view?
See, that depends on the kind of question that has been raised. So now some cases there aren't Supreme Court judgments available on that particular fact. So high court judgments have persuasive value. Actually, this has happened to us in our moot courts also. So they always ask you, what is the relevance here? You need to actually tell them that this has a persuasive value and the courts can consider it. So they would take into consideration accordingly the opinions that has been presented on the same matter by other judges. It would not go waste. So it doesn't really matter that only Supreme Court judgments would be binding on a particular thing. But yeah, High Court judgments do have a persuasive value.
Is it the same with the website, that a lot of times they're like, okay, fine, we won't consider a judgment from this website. Is it relevant in the national moot courts?
I don't think that is really until
It doesn't matter the side.
If you're going for a moot which specifically provides that say SCC online is a moot is a sponsor, or Manupatra is a sponsor, it is quite recommended. It is well recommended that you should take the printouts of the judgments from SCC or Manupatra. But I would say that it does not affect the.
It's not mandatory per se to just get judgment from Manupatra or SCC online. If they are available on other sites and the content is exactly what has been provided there, so you can take them from there also.
Okay. Thank you so much.